Good morning, everybody. My name is Cassandra Janicki, and I am your instructor for business law at Columbia College. Today, we're going to be talking about chapters 3 and 44 in your book. These two chapters, though far apart within your book, have an interplay between them that I'll be explaining today. So let's start with what is business ethics? Now, when we think about ethics, I think it's totally fair for each one of us to think about what our own personal value system is and how that applies to what we do in everyday life. Consistent with that is also evaluating how our personal value system plays into how we interact with our workforce, how we interact in business negotiations, how we interact really in any business relationship even. And so business ethics is a smaller subset, I think, of our own personal value system. And it's how we interact in a professional manner when we're dealing with anything related to business. So, what is business ethics? Well, ethics as a broader concept is a branch of philosophy that deals with values relating to the nature of human conduct and interaction and what values we associate with that conduct: good, bad, neutral, evil, things like that. Business ethics balances what is a very, readily recognized goal of business, which is to gain profit, and how that goal can interact with individuals and society, and then how do we balance those two things. So there are a variety of different types of theories surrounding business ethics that try to explain business ethics. And these are concepts and theories that we'll walk through. And then at the end of this particular section, we will talk about how your business ethics can impact profit, and then how you may recognize and then resolve a business dilemma. So the law, right? These things that we've been talking about for several weeks now, right? Common law, statute, constitution, court cases. The law, as we know it, can act as a standard for business ethics. Pretty straightforward concept. It's basically a positive law theory. If an act is legal, then it is also moral. Absent any illegality, all behavior is ethical under this very simple standard. But I think we can all agree that just because something may be legal doesn't necessarily mean that it is also moral at the same time. So a different, theory under business ethics is the notion of universal standards. And this is a natural law concept, right? It's one that is higher than a positive law standard, right? If positive law is the floor, where, if it's legal, it's ethical, then the notion of a universal standard for business ethics is a step above that. It's a higher standard of conduct than what would be allowed under positive law, and it has to be followed even if it goes against codified law, meaning that even if something is legal, it doesn't mean that it is also ethical at the same time. And so those two simple but competing theories of business ethics really acts as I said, our floor for the understanding of business ethics and the variety of theories that go along with it. Now, if any of you have ever taken like a philosophy class or an ethics class, you will have heard of some of these philosophers and ethicists who really tried to evaluate how ethics plays into and can be categorized or interpreted based off of human interaction and conduct. So when we look at Immanuel Kant's categorical imperative, that is boiled down to into a theory where we cannot use other people in a way that gives us a one-sided benefit. And if everybody is operating under that same usage of law, right? I can't use you or engage in conduct with you that's going to convey to me a one-sided benefit, then we all have to be fair and righteous, and we must want to do things for the right reasons. Now, Locke and Rowe came after Kant and said, listen, when we're looking at a theory of justice or the social contract that we interact with each other as human beings, then that is also developed out of the result where we all focus on fairness. If the result is fairness, then as contractarians and justice focused individuals, then if the end result is fair, the behavior was ethical. Another theory that you may hear thrown about is the rights theory, or also known as the entitlement theory. Everybody has a set of rights, and the government is set up to protect them, right? And so we, as American citizens, really operate under this rights or entitlement theory, right? When we think about like the penultimate legal document that is supposed to govern how we interact with each other as American citizens, our Constitution, there is an entire Bill of Rights encapsulated within that document that is purposed with preventing the government from inappropriately overstepping our rights. And so we operate, in theory, again, under this rights or entitlement theory as American citizens. Now, a couple of additional ones, these are all of these theories are just a basis for us to evaluate and understand the impact that ethics and how we make decisions and what our intention is can affect an outcome, right? And so an ethical egoism theory, that theory is an interesting one because it's focused on the self, right? We should act in our own self-interest, and we only judge ourselves. So we make no moral or ethical judgments of other people's behavior, and we're really just focused on getting what we need in order to survive and thrive. The utilitarian theory is one that I think a lot of folks are familiar with, right? And this is the concept of doing good for the largest amount of people possible, right? And that is one that is very oppositional in theory to the ethical egoism theory, where you're thinking about number one versus thinking about the group as a whole. And then moral relativists, this is the every situation is different, folks, is what I like to think of them as. These are standards, and we place into usage ethical standards that are based upon the circumstances. And therefore, we have no predefined standards because every situation is different. These are our totality of the circumstances, folks. And then, of course, we have Plato and Aristotle, like the OG, philosophers and ethicists who really focused on understanding that using ethics and applying your values to situations requires training, right? It's a muscle that we flex and that we have to work because we are oftentimes poised with ethical dilemmas that sometimes we don't even recognize as ethical dilemmas. So recognizing it can take effort and work and training. And then how do you resolve it? What's your thought process for getting through those issues? And so that's really where the business stakeholder standard of behavior comes in. So stakeholder analysis and this theory of ethical decision-making in business really measures the impact of a decision based on how it impacts various groups and asks itself whether or not public disclosure of that decision will be defensible. And so when we think about our own personal value system, right, and if we're faced with an ethical dilemma that we have to resolve, we utilize our own personal belief systems and we make a decision based off those. And then we may or may not face, right, any sort of public censure as a result of that. But the reality is that business versus personal, business is always going to get that public piece, because more often than not, everything that you do in business somehow has a public implication, somehow has a disclosure requirement, versus doing it personally, where you may not have to tell everybody and their brother that you made a decision and what you based it on. So here are the guidelines that this is one way for us to interpret how to make a decision in an ethical dilemma. So you're going to define the problem from the decision maker's point of view, right? So typically, if you're the business, this first piece is going to be, okay, what is the problem from our point of view? Then think about who is going to be impacted or who could be injured by the contemplated action. By doing that, you're taking into account the totality of the circumstances, right? And it's important, as part 3 here delineates, to think about the problem from the opposing point of view, because you don't ever want to be married to just one understanding of the problem or one point of view of the problem. And then would you, as the decision maker, and this is that public piece, are you willing to tell everybody, your family, your supervisor, your CEO, the board of directors, everybody and their brother about the planned action? And then are you willing to take that even a step further? Are you willing to take it to a community meeting, a congressional hearing, a public forum to describe that action? And if that's true, if all of that is true, then you could find and decide that your decision, right, the action that you are contemplating, is the right one to take. Now, why? Why are business ethics important? Why are we having a class about this? Why is there a chapter about this? Why is this important? Well, it's that public piece, right? It's that public facing piece that can really, really impact how your business survives and thrives walking through an ethical dilemma. So capitalism in and of itself is a system that requires trust. It requires trust in our markets. It requires trust in our regulators. It requires trust in its participants, because it's oftentimes viewed as kind of a little bit of a shell game. And so you have to be able to trust the other parties within the capitalistic system. So we rely on the promise that businesses will produce good relationships, that they'll produce good relationships amongst themselves, with their customers, with their employees, with the government, and with the public. So failure to implement good business ethics can damage trust with all of those parties that I just described. And if you don't have trust, then you are going to see your financial performance decrease, because financial performance, particularly in a capitalistic system, is based on, utilizing a strong value system to survive those with a weaker value system. And that's because good reputation matters, right? Like a company's name, their image, if it's good, if it's bad, if it's neutral, all of that can have a really big impact upon its ability to do business. Who would you do business with? Who would you prefer to do business with? A business that's got a good reputation, has a reputation of being trustworthy, having good ethics, or are you going to pick the shady one? The one that's got questionable moral standards, that doesn't stand up for anybody? You're not going to pick that one. You're not going to pick that one. So the other competing piece of this, right, is that when you have good ethics, and the importance of good ethics, is that the way that you conduct business can impact business regulation creation and implementation and application to yourself. So when a business behaves poorly or unethically, you can rest assured that if it has a big enough impact in its community, on the area of business that it's in, that there may very well be a soon to come accompanying law change that is geared towards preventing that type of behavior in the future. Some super good examples of that, which we're going to talk about a little bit later when we talk about accountants, but the early 2000s accounting crashes, right? When we think about Enron and we think about WorldCom and we think about why those businesses went down, it's because, in part, those businesses and the accounting firms that they were utilizing had remarkably poor business ethics. Like, their value systems were completely gone by the end. They were simply trying to get away with their previous bad behavior and avoid people finding out about it. And all that did was lead to huge federal investigations that now have created a whole new world, so to speak. I mean, it's a decade and a half old by now, but a whole new world of how we hold businesses and accountants accountable and liable for their actions, particularly with publicly traded companies. And so all of that is to say that when we think about the importance of business ethics, businesses that respond to social forces, that listen to their community and focus on having positive societal interactions with that community based on good values and good business ethics, those are the folks who have a competitive advantage. Those are the folks that draw business to themselves. Now, what are some of the things that you hope businesses think about, right? Where do your business ethics fall? Oh, sorry, I made a formatting error here with protection of the state, but thinking about that, there's this whole myriad list of things that you want to be thinking about when you're thinking about business ethics. How do you protect the state? How do you protect the person? How do you protect public health, safety, and the morals of society? Are you protecting property? Are you protecting personal rights? What is your individual intent? What are you trying to protect people from? Is it exploitation, fraud, or oppression? How do you further trade, but you do that in an ethical manner? How do you protect creditors and rehabilitate debtors, right? All of these things lead to this concept of the importance of business ethics, because business ethics is an incredibly complex area that we have to address. Now, you're probably saying to yourself, well, Cassandra, thanks for that lecture. Like, I get it, but like, talk to me about some real world stuff. What do we do? What do we look at, right? Well, sometimes you're going to be thinking about what are your categories of ethical behavior, right? What are your values? What are your ethics regarding integrity and truthfulness? Is that a personal value of yours? And if it is, how do you play that out in a business area, right? How do you play that out in your employment? Are you keeping promises? Is that a personal value that's important to you that translates to business ethics for you? How are you loyal? How do you avoid conflicts of interest? How do you do no harm? And how, if you have to, do you maintain confidentiality when it comes to business ethics? And so these are all of the categories of ethical behavior that you should be contemplating as you're developing your own style and your own set of business ethics. And these are also the categories of ethical behavior that, let's say, for example, when you're looking for a job or when you're thinking about interacting with or entering into maybe a contractual relationship with another business. These are the categories of ethical behavior that you want to evaluate that other business by. How do they maintain their integrity? Are they truthful? Do they have transparency? If so, what does that look like? What's their record of, keeping up with their promises and making sure that they are loyal to the people that they should be? How do they do no harm? And do they maintain confidentiality? So there are a couple of tests that you can utilize. I'm going to describe 3 of them here for you. And then in your lab assignment for this week, there's also another standard that you're going to be utilizing and applying, or that you can utilize and apply in some scenarios that I provided for you in the lab. So there's the Blanchard and Peel 3-part test, right? And you use these 3 questions to evaluate each situation. Is it legal? Is it balanced? And how does it make me feel? I really like this test because I think it's simple in concept and it can lead to a larger conversation. So, is it legal? That's our positive law piece, right? From the very beginning. Is it legal? And if it's legal, does that make it moral? Does that make it ethical? Then the question, is it balanced, right? That's really trying to get you between that like categorical imperative concept and that self-focused test, right? Like, is it balanced? Does it benefit both parties in a way that's fair? And then I always like this one. How does it make me feel? And I like that one because sometimes we have a gut reaction to a situation, and you would be surprised how often that gut reaction is accurate, right? If it makes you feel icky, or it makes you feel not good, or you have a question in your brain, delve into that, lean into that a little bit more, because what you really want to do is at the end of the day, make a decision that you will feel comfortable with and comfortable defending into the future, right? So that question kind of leads us into the next piece, which is the front of the newspaper test, right? Like that is whether or not you think publicly splashed on the front page, you are going to be able to survive and sustain whatever kind of backlash you may get for having made that decision. And then lastly, we have the Laura Nash model, which really focuses on in all perspectives, totality of the circumstances evaluation. It's kind of like that 6-part test that I described for you before. Define the problem, because that will help you avoid the dilemma in the future. And then ask for your perspectives from your family and your friends. Ask for the perspective from those folks whose opinions you value the most, because those are the people who, if they have feedback about it, those are the people you're going to listen to the most. So now that we've kind of talked about the larger scope of business ethics, right? Chapter 44 really focuses on accountants. And you may ask yourself, well, Cassandra, I don't really understand, like, why are we teaching these things at the same time? Why are we interacting these two things at the same time? What is that? Well, when I think about so many of the federal laws that govern accountants, particularly as it relates to their interaction with publicly traded companies, so much of that law evolved from ethical dilemmas that were handled poorly, and that were handled in a way that had long-standing, trailing effects on so many people. And so when we think about the general principles that govern, like accountant liability, malpractice, and negligence, so many of the laws that are in place right now came from accountants and companies that had bad ethics. And so that's how these things are interrelated. So when we look at the general principles for accounting liability, you've got some common law liability. We're going to talk about negligence, and then we're also going to talk a little bit about fraud. So for common law, right, the question really is, what constitutes malpractice? And so accountants have a duty to exercise the skill and care common for their profession. That is a pretty standard, so to speak, across all professions. Like, I, as a lawyer, also have that malpractice standard where I have a duty to exercise the skill and care that is common for my profession. If an accountant fails to render services in accordance with those professional standards within their community, then the result is malpractice. And that, take us all the way back to the beginning of our class, right? That is a tort, so a civil harm, and it comes in the form of negligence or fraud. So accountants are typically not normally liable for detecting fraud. However, they can be liable for ignoring suspicious activity that could be fraudulent, right? They're going to have a reporting duty to a variety of people, and I'll describe that for you in a couple of slides. But accountants are also not allowed to commit fraud, right? So they may not be liable for failing to detect fraud, but they could be liable for failing to report suspicious activity. And then if they are actively engaging in the fraud, that is another way to sue them for malpractice, right? So several different types of causes of actions that you can take against an accountant if they commit malpractice. Now, another common law liability, right, is one that we know, one that we love, right? It's a breach of contract claim. We love contracts. We just spent, 6 weeks talking about nothing but contracts, right? So a breach of contract liability theory, right, for an accountant is going to be serious, right? If there is a serious breach of contract, if there are damages for minor errors that are detected or deducted, when we're talking about a breach of contract claim, we're talking about something really serious, and then they're not going to get paid. If we're talking about like some minor errors, could be a breach of contract, could just be something that you don't give them, as much money for. And typically, absent a third party being involved in the contract, right, being in privity with the accountant, we're not going to have any breach of contract claims by third parties. Now, as I mentioned earlier, the tort liability piece, that's going to be a client or a third party who can recover from the accountant based on their malpractice under a theory of negligence or fraud. So when you're thinking about how an accountant can be liable, you got to think about their level of liability to two different parties, right? So what's their liability to their client? And then what's their liability to everybody else? Typically, accountants are going to be in contractual relationships with their clients, but they are not, very rarely actually, going to be in a contractual relationship with a third party that is not their actual accounting client. And so what's the level of liability they owe to their client? And then what's the level of liability that they owe to these third parties? So our common law theories are going to be valid in a limited number of circumstances. And this is because we have so much statutory law now that governs accountant liability. So the other piece to always think about, and this is if any of you go into any sort of profession where your licensure, right? So like a doctor, a lawyer, an accountant, a teacher, you don't just get to say, hey, I don't know how to do this, so you can't sue me, right? You don't get to just be like, I don't know how to provide this service, but you can hire me for it anyway, and I'll figure it out. You are still liable for those things, right? And so you're still going to be liable for those things, particularly if you knew or should have known that something you were doing or saying was false. And that's that fraudulent piece. You're never going to be able to exculpatory provision your way out of fraud or negligence, typically. Now, that's how you're liable to your client, right? If you're an accountant, but how are you liable to third parties, right? And I described a little bit this concept of beyond privity, but beyond privity really focuses on whether or not a contract exists between the two parties that are in conflict, right? So typically an accountant is going to enter into an audit or an accounting contract with a client, right? They're going to be hired to perform an accounting or an auditing service. But what liability an accountant may owe to a third party varies based on what jurisdiction you're in, what type of activity you're engaging in, and then what type of theory is applied. And very often, what level of knowledge the accountant had or should have had about how other third parties would utilize their information. So let's talk about it. Now, a quick primer, right? We haven't talked about this yet, but the concept of an employee, an independent contractor, an outside auditor, what will constitute negligence is the same regardless of whether or not the accountant is an employee an independent contractor, or an outside auditor. It's not going to matter if you pay them a salary or you pay them a fee. It's not going to matter. Negligence applies regardless of the accountant's individually employed status. Now, I mentioned that there are a variety of different conflicting, theories of how accountants are liable to third parties. And so we start with the privity rule, which is like the easiest one and the one that I think if I were an accountant, I would want to apply it all the time, because then a third party could never sue me for anything, right? Because the only person who can sue me is my client. But I think we all understand that that is such a limiting rule, because we know that there is a large amount of our society that has to rely on accountants and the representations by accountants in making investment decisions, business decisions, contracting decisions, all those types of things. So the next rule is like, and these are kind of like step up, right? Like, and if we're stepping up in we're going to protect the third party more than we're going to protect the accountant. So the next one is the contact rule. And this would allow a third party to recover if they had some contact with the accountant about the thing that is at issue. Increasing step, right? Then the known user rule, where the accountant will be liable to a third party when the accountant knew that the third party would be using the information. So a good example of this is if you're in a business purchase negotiation and an accountant is retained in order to evaluate the books or to do an audit or to clean up the books to present to the other business. In that instance, the accountant knows that the other party is going to be using that information and making a decision. So if there's some negligence that is committed by the accountant in that exchange, then that third party, the known user, can sue the accountant for that negligence. And it won't simply be that their contractual or privity client can sue them. Foreseeable user rule will impose a liability on the accountant if the accountant could reasonably foresee who would rely on that work. So the foreseeable user rule is also one that is applied in the larger kind of financial disclosure world, right? Foreseeable and intended user rule, because those accountants that are doing, let's say, the books for large, nationally traded companies, they know that their accounting work is going to be utilized by investment brokers, investors, employees within the company, like all of those things. So if you were a foreseeable or an intended use user of that information, then you, as the third party, not in privity with the client, can sue for negligence or fraud. One more. So the unknown user rule, less applied, right? Kind of the most broad, if you will. A non-privity party cannot recover for negligence if the accountant had no knowledge of any using or any use affecting the party. So, if the accountant had no reasonable ability to know that you would use it, you don't get to sue for that. The flexible rule, some courts don't use any of these rules because they evaluate each case on a case-by-case basis, and they reject the concept of privity, because they understand, I think, in some aspects, right, that in the world that we live in, you got to be flexible, because you have no idea until you know the facts of an individual case which rule is going to best apply. So flexible user rule. Now, typically, these are the folks that accountants are not going to be liable to, right? So interlopers, people who are just Joe Schmo, the rag man, walking in off the street, accountant has no notice of, no nothing, no. Accountant's not going to be liable to them. Parties affected by the decision of the accountant's client. So, if the client is making a decision based off of the accountant's work, and if the work is negligent, then the accountant, again, based on all those kind of other liability rules, might be liable if you can fit under one of those theories. Now, all of this might make you say, God, I'm going to rethink my decision to be an accountant. I'm gonna walk that back all the way. Listen, accountants are held to a higher standard, as many professionals are. But fear not, our future accountants, because you do have some defenses to your own liability. And that is really focused within this concept, bringing it all back to the beginning, right, of negligence, contributory and comparative negligence of either the client or the third party. So if we're looking at contributory negligence, remember, contributory means if you contribute any negligence to a situation, the accountant will not be liable. Okay. If the client is negligent, then that may reduce or eliminate the accountant's liability. The accountant has to show that the client contributed to the accountant's failure or ignored the accountant's instructions. Okay. Comparative negligence, right? So you're not losing all of your liability, but you're going to lose some of it. Accountant and the client are assessed a percentage of blame for their respective negligence, which then will reduce the client's recovery against the accountant, right? So let's say, for example, the client gives bad numbers, or the client gives books that are, a lie, things of that nature. The accountant can't be held liable for that, or can't be held solely liable for that. Now, we've talked about fraud, right? And the difference between negligence and fraud is what? Intention and knowledge, right? And so when we're thinking about negligence and fraud and the difference as it applies to accountants, negligence is you maybe knew, or is maybe you made a mistake, or you just weren't as careful as you should have been, right? Versus fraud, where you lie. Right? It's a false statement that you made knowing it was false, or that you made with reckless indifference to the truth. And so an accountant's fraud liability to an intended victim, right? So someone that the accountant intended to defraud, victims can recover from the accountant for loss caused by fraud, and a contract is not going to be required, right? So if the accountant was trying to defraud stockholders, they get to sue the accountant. If he was trying to, who are not in privity with him, right, not in a contract with him, they get to sue him or her. Now, I mentioned and alluded to, like, why are these things connected? Why are these, chapters connected? And I really do think that we as a society have been faced with several large scale, like, financial system ethics questions in the last 2 decades, right? The first is when we came to understand that auditors and accountants were lying. They were just lying all over the place. And that was in the early 2000s when we had the WorldCom bust, we had Enron bust, and all of those, like, larger companies that are no longer with us, that were utilizing fraudulent and negligent accounting practices on the regular to try and boost their numbers, right? Boost the profits. And then, of course, we had, which we'll talk about later as we when we get into our discussions about stocks, when we start talking about corporations, the 2008 crisis, right, where we saw, again, just some really unethical behavior by businesses to try to boost profits, right? So this is, and where does that come from, right? Where does that come from? That comes from a lack of business ethics, or poor business ethics, or the choice to not employ good business ethics, right? So when we look at the federal laws that govern auditors, accounting, and financial reporting, these are the ones that are going to be specific typically to publicly traded companies, right? When we think about the application of federal law to any situation, it really has to implicate a constitutional question, a constitutional right. And when we talk about federal financial law, that is typically going to be limited to situations that impact what? Interstate commerce, right? So SOX, you can call it SOX. It stands for the Sarbanes-Oxley Act. And this law really developed in response to Enron, in response to WorldCom, looking at the fact that we as a society did not have adequate independent accounting oversight on these publicly traded companies. So what do? They create a board that's responsible for promoting high professional standards amongst auditors, and then working with that, for companies who issue securities, they have to file registration statements with the PCAOB, and then auditors have to remain independent. So you're not going to be an auditor that's hired and retained by a company as an employee. An auditor is typically going to be that independent contractor who is independent and makes independent decisions and offers opinions independent of the person who is paying for the audit. Auditors are like above all of us. It doesn't matter who pays them. They're just supposed to be telling you the truth. Now, as I mentioned, board members who sit on the audit committee are supposed to be independent, no fees from or affiliations with the company, certain employees or any subsidiaries of that company. And then of course, because we all, well, maybe we all don't know, but one of the things that Enron got busted for doing is just having some shredding parties. They just shredded stuff. So we don't do that anymore because the Sarbanes-Oxley Act requires records retention, 20 years if you fail to do so, or if you get caught shredding or destroying documents during an investigation. And then lastly, Dodd-Frank developed out of the 2008 crisis. And one of the things that we knew coming out of the 2008 crisis is that even though the housing crisis wasn't directly layable at the feet of accountants, what we understood is that accountants knew or should have known that there was some shady stuff going on, and then they failed to tell anybody about it. So the Dodd-Frank Act requires auditors to report fraud to the management of the company, the board of directors of the company, and if nothing comes from that, to the SEC, which is the Securities and Exchange Commission. Whistleblowers are those people who reveal potentially fraudulent behavior, suffer a negative employment consequence as a result of being a whistleblower, and who then remain unemployed. These poor people remain unemployed pending the investigation by the SEC. If you're a whistleblower and all of those things are true, then you can be paid by the SEC, not by the SEC, but you can get damages from the company that you whistleblew on. And so under Dodd-Frank, whistleblower rewards only come from reporting conduct that was intended to thwart an SEC investigation. So that is all that we have for today. I hope you enjoyed this lecture. If you have any questions, please feel free to visit me during office hours. I look forward to discussing with you, and you'll be implementing some of these things that you learned today on our new lab assignment for this week. So I can't wait to review them and see what you guys think. Have a great day.